Tony Seaton has practiced as a personal injury trial lawyer for 45 years. And for over 40 of those years, he has served in some role with the TTLA and its affiliated organizations. In 2021, Tony was the president of the Tennessee Trial Lawyers Association. From 2012 to 2018, he was appointed by the Tennessee Supreme Court to the Access to Justice Commission, where he traveled to every judicial district in the state, putting on free legal clinics. About 15 years ago, Tony partnered with Keenan of the famed Keenan Trial Institute, and he became the national administrator of that institute, at one point overseeing more than 100 instructors throughout the country. About 2 years ago, Tony partnered with Keenan and helped create an AI version of the Keenan Trial Institute. It's called the Keenan Artificial Intelligence Avatar. We'll put a link to that in the description of this video. In 2023, Tony received the TTLA's highest award, the Lifetime Achievement Award. And today, he reports that he happily manages just 4 cases, down from, at one point, as many as 500. Well, speaking of the Keenan Trial Institute, that's kind of where I want to start. You know, this is the Tennessee Trial Lawyers Association, but increasingly, I don't know the stats, something like 90 or 95% of cases don't go to trial. They resolve some other way. How do you get to trial anymore? Is it something you're doing? Is it something the other side is doing? You know, how does that happen in today's age?
Well, I mean, you get to trial by driving your case to trial when you want to go to trial. I think that your statistics are borne out by there are so many lawyers out there taking cases and settling them for a lot less than what they're worth. You know, that's part of the problem that we've got in our industry and in our profession is, you know, people aren't taking things to trial. They're setting themselves up as settlement mills. I can remember when I first started practicing law, real estate lawyers were taking personal injury cases and they were trying to get them settled. And if they couldn't get them settled, they'd call me. You know, so you know that's pretty much what's going on right now.
So you think it's mostly an incentive to just churn and settle cases for pennies on the dollar, and so more so you should try cases when damages maybe is the key issue? Or
well, yeah, absolutely. I do think that you know, it's like when I talk with other lawyers and other law firms, you know, statewide, and I'll ask them, how many cases have you tried? And they'll say, well, none. You know, the judges are there. The judges are usually available to try cases when you want to try cases. But there's so many lawyers that just have a settlement mentality. They take a case, they hope that they can get it settled. If they don't, they go, oh my goodness, okay, let's throw it together and get it to trial, and then they don't get a good result.
Yeah. Well, speaking of that, on the intake side, choosing the case on the front end, obviously some things will be a no-brainer, but can you tell me something about how you evaluate a case, maybe for this reason to go to trial, or just generally, you know, where you've evaluated a case maybe in a way that another lawyer undervalued it or didn't take it or something like that? You know, what's your kind of advice on intake?
Well, it's interesting that, you know, most of the big verdicts that I have received in 7 and 8 figures were cases that other lawyers turned away. I've always said that I can go through a lawyer's inventory of cases and I'll find out of 100 cases, I'll find 2 or 3 wonderful cases that they are completely undervaluing. So, you know, what are the criteria that I'm looking for? You know, we're looking for systematic failures of business or industry, you know, that are going to continue to be systematic failures that are going to infuriate people because of their continued conduct.
Gotcha. Well, maybe you can say more about that. So systematic failures, are these, what sort of cases were these? Are these medical cases? Are these, you know, what sort of industries are we talking about?
Well, anything. You know, one of our biggest verdicts was a 380-pound woman who slipped and fell in an icy parking lot. And what we found out was that the parking lot people were owned by a big conglomeration. They had no desire to keep things safe in that parking lot. They had lots and lots of other apartment complexes that they were doing the same thing. Another case that I had was where a woman got rear-ended by a box truck. Well, you think, okay, you know, how bad is that? Well, when they opened the door to the box truck, the guy rolled out. He was on 5 different controlled substances, and he was transporting dangerous drugs from pharmacies to disposal sites. There was no supervision. There was no inventory system or anything. So, it's those types of system failures. It can happen in the medical environment too, where, you have hospitals that just have no processes or procedures. You have nursing homes that, are so focused upon profitability. And of course, that's one of the other things. It's like the problem that we have is industry is focused upon profit. We are focused upon accountability. And those two concepts aren't compatible.
Mm-hmm. Yeah. I see what you mean about the woman in the parking lot. I imagine that one would have been perhaps declined by many other lawyers, and certainly not the result that you got, it sounds like. You mentioned before we started filming this, that one of the things you wanted to talk about was knowing what you know today, how you would train to be a trial lawyer in today's era. Is there something specific you want to say on that? Is there some sort of daily habit or routine you have that you would pass on?
Well, the question is, what would I do if I were sitting down with Tony Seaton when he first got out of law school? What type of advice would I give him to become a good lawyer? And what I would say is, one good habit that I've always had is I've read the cases. You can go to TBA Today or whatever. You get the cases on a daily basis, and I read the cases. If you read the cases, you know how the courts are thinking, and you don't get yourself in trouble. You don't file a 1983 action type of case without knowing what are the elements of that. So you get into that routine of knowing what they're looking for. The second thing that I would say is that I would tell myself, you need to do whatever you can to get trial training if you're going to be a trial lawyer. You may not have the substance to be a trial lawyer. And if you don't, you probably ought to recognize that. You need to know yourself. Are you a trial lawyer? Are you the kind of person that is a tenacious fighter and a risk taker? If you're not a tenacious fighter and a risk taker, I wouldn't try to call myself a trial lawyer. And, unfortunately, in a lot of the classes that I've taught, I will have, say 10 lawyers in a room, and there won't be but 1 or 2 real trial lawyers that have the substance to do that. It's a very, very stressful type of thing. It's like you sit in a courtroom and your stomach's up in your throat, and you've got 4,000 things going on. It's very stressful. But the best thing that ever happened to me was 15 years ago when I met Don Keenan, and Don Keenan taught me a very good methodical way of trying cases. Everything from case intake all the way through jury selection, all the way through direct exams, cross exams, focus groups, closing arguments, et cetera. Because I think I may have mentioned, we taught 24 different courses under the Keenan Trial Institute. When I first got out of law school, there were these week-long trial institutes. It was like the National Institute of Trial Advocacy or something like that. And I went for a week to one of these camps and learned quite a bit. I learned now as I got older that I had to unlearn a lot of the things that I learned when I was very, very young. But that's the best method. And that's what I would tell myself if I was sitting down with myself, when I could have first gotten out of law school. I'd say number one, find a good mentor. Mentors are critical. And there's lots of us that are willing to do that. It's not like I want your case or anything. I've got mentors in Knoxville and Nashville, people that I consult with in Johnson City regularly, and they're bouncing things off. But find you a mentor, number one, and then number two, find you a good trial training way. I mean, I am very partial to the Keenan Trial Institute. I still heavily believe in it, but it's not the only way. There are others. But the mistake that I made was thinking that I was going to learn to be a trial lawyer by going to conventions and going and hearing speakers who weren't really there to teach me anything, They were there to tell me how great they were, and that I should be hiring them to get their case. And that's unfortunately one of the problems that we have with associations, whether it's Tennessee Trial Lawyers or Association of Justice. You have these conventions, and people aren't teaching you their methods. They're trying to razzle and dazzle you. So
Right.
that's where I would go with that.
That might be a good spot to pick up on this AI tool that you've got at the Keenan Trial Institute. Maybe tell us a little bit about what that is and how that can maybe help.
Well, one of our learned members, Josh Cantrell, and I had gotten together a couple of years ago, and Josh introduced me to a lot of ChatGPT, and as we were learning a lot of AI stuff together, he looked at me one day and he said, "Wouldn't it be great if we had this Keenan stuff all into an AI tool?" And I thought, hey, I know Don Keenan well enough to talk about that. So we put that together, and essentially Don Keenan rolled in about 3,000 videos that he had done. He's a very teaching individual, and he rolled in all the 24 courses. The great thing about the Keenan Trial Institute, the way they teach things, they don't just sit there and lecture you. What we do is we will ask you questions of what you think. We will show you that you are wrong. Then we will get you on your feet, and then we will teach you so that it's ingrained in you. So all of our methods are, some teaching, but mostly getting on your feet and learning how to do things so that they become ingrained.
Well, we'll put a link to that in the description of this video. That'd be great.
So let me finish. I got off on the Keenan Trial Institute. So once we rolled all of that into the what we call the Keenan artificial intelligence avatar, now we have Don Keenan at our fingertips where we can ask him any questions that we want. We can say, Mr. Keenan, what do you think about this narrative of a case? We'll give him 3 paragraphs, and he'll say, give me more information, and he'll critique your case. And then we'll say, well, what do you think we should be focusing on in trial? What do you think the defenses are going to be? What kind of jurors do you think I need to have? What do you think I ought to be focusing on in the closing argument? How should I put my exhibits together? All of that is now instantly available, at your fingertips.
Yeah, that's awesome. Definitely worth checking that out. Well, that might go nicely into this next question, which is, what are the mistakes that you see young trial lawyers make? Is there just one common one, or several, or something that makes you pull your hair out, or you wish you could tell them to do it differently?
Yeah, the mistakes that most lawyers make are, number one, they take way too many cases. It's like, and I can remember that. I've been doing it for 45 years, and I used to think, gosh, if I don't take this call, if I don't take this case, maybe next month I'm not going to, be able to make payroll. I mean, right. and that's unfortunate. But so taking too many cases and not being able to focus on the good cases is a huge, huge problem. I did it for years and years and years, and like I say, I'm down to 4 cases now. Of course, I'm not practicing completely full time, but that's that's what I do. So I see those mistakes. I see the mistakes of not moving cases. When I was a young lawyer, I had an old judge, and he was just a cranky old son of a gun. And he looked at me one day and he says, Tony, he says, let me tell you one thing I like about you is that you, one thing. He says, I like the way that you move your cases. And so it's like, time is to the benefit of the defense. If you're not moving cases, you are shortcutting your client. There are ways to move your cases. You can have scheduling orders and things like that, like they do in federal court. A lot of people don't like to have those because it's accountability. But, right. I want to see lawyers moving cases and getting their stuff together and working hard. If they're not working hard, it's not going to happen.
Right. That's a great point. Let's talk a little bit about that access to justice stuff. Sure. You did. It sounds like you went to every judicial district in the state. How did that help your practice as a person, make you a better person, make you a better lawyer? How important is that sort of pro bono involvement to trial lawyers?
Well, what we did, we started a free legal clinic. It was modeled after one in Murfreesboro. And, we probably 15 years ago in Washington County, Tennessee, we started a free legal clinic. And we would just go on a Saturday for 2 hours. And we just give people guidance or legal advice. We don't take cases, although sometimes we do take cases, but for the most part, we don't. And so it's 2 hours a month. And so it just became a very rewarding part of my practice. I mean, money is not the end all. I enjoyed making a good living, but I also enjoyed it, when a little old woman would come up and say, "Oh my gosh, you are my savior. Thank you. And can I give you a hug?" And so,
Yeah.
once we got, Johnson City up and running, and once they put me on the Access to Justice Commission, then I started traveling. And what I would do is I had a team, and we would put together a bar association meeting with the judges, and we would get the judges involved, and we'd say, "Hey, you can do a free legal advice clinic on a park bench. You don't need a phenomenal facility. You don't need help.
Mm-hmm.
You don't need equipment. You can sit on a park bench and help people." And so we went around the state, and for the most part, we've got clinics going in almost every judicial district.
Oh, that's great. My last question for you is just about this organization, TTLA. Why is this an important organization for people to continue to be a part of, or for young lawyers to join? How important is it?
Well, it's extremely important because, it's like I said a minute ago, business and industry, if they had their way, there'd be no accountability whatsoever. I mean, it's simple. I mean, they want to make a profit. We stand in the way of holding them accountable. And so if they were never accountable, then there would be no reason for us. And so, probably 60 years ago is about when the Tennessee Trial Lawyers organization was put together by Jerry Summers, Olin Haynes, and some other great trial lawyers, because the government or the legislature in Tennessee was absolutely destroying lawyers, or destroying people's ability to hold industry accountable, which also affected lawyers' ability to make a living. And so without lobbyists there, and without some ability to convey to legislators what our causes were, we were losing and losing and losing. One of the great examples of that is, we used to have a great workers' compensation system. When a worker got injured in the state of Tennessee, there was a good system where they could get medical benefits for the rest of their life, and they could get some compensation. Of course, as the governors went through, and these were both Democratic and Republican governors, they decided Tennessee needed to be a business-friendly state. Profit was more important than individuals. And now we have a workers' compensation system that is horrible.
Mm-hmm. Yeah, I think TTLA is trying to change that. So that's all the questions I have. Is there some question I didn't ask that, some parting shot of advice you'd like to give, or anything else you'd like to add?
I would go back. I think the most important thing that I have learned and that I have said is, if you number one, know yourself. I mean, do you have the substance to be a trial lawyer, if that's what you want to be? And then secondly is to find a good teaching method and a good mentor. To me, that would be critical. I always say that I practiced law for 30 years, and I hope the statute of repose has run, because I tried some really, really big cases in a terrible way, and got some really bad results. And it was only after I really learned all of these techniques, did I feel comfortable. I am comfortable in a courtroom. It's like, as I walk in, I have everything. What I always do is I put everything in notebooks like this, and I take that stand to me, with me to trial. And I have everything organized. I have a team of people working. I've got a team person that's working on my witnesses, putting them together. I've got a team person working on my exhibits. I've got a team person working on computers. I've got a team person or two team people working on watching the jury and helping me pick a jury, and they're highly trained to do that. So it's like, I'm not in there stressed out about 4,000 things that can go wrong. I've got good people that know what they're doing. It's still stressful, of course,
Of course, yeah.
But that's, that I would say has been a tremendous assistance in making cases successful.
All right, Tony. Well, thanks so much for joining us, and
Great.
thank you very much.
Thanks for having me.